Welcome to This Explainer. Today, we're unpacking something that affects literally every single one of us, yet it's a topic completely surrounded by confusion and incredibly high stakes. The source material explores the fascinating world of testate succession. That's the set of rules governing what happens to your property when you die with a valid will. And it turns out, under South African law, drafting your final testament isn't just about jotting down your wishes on a notepad. It's a really rigid legal balancing act. Today, we're going to explore this massive tension between incredibly strict legal formalities and honest, everyday human error.
So let's kick things off with a pretty massive question about your legacy. What actually happens if you make one tiny, seemingly insignificant mistake on your will? Say you just forget a signature on page 2, or maybe your witness is a day shy of their 14th birthday. Do your final wishes just vanish? This single question sets up the real drama at the heart of our law. How exactly does the system balance unforgiving legal formalities with well-intentioned people who simply make a mistake?
To figure this out, here's our roadmap for today. We'll start with the strict rules of wills, then hit the ultimate validity checklist, look at amendments and codicils, explore the court's safety net, and wrap up with some common traps you absolutely need to avoid.
All right, diving right into part 1, the strict rules of wills. Are they about protection or just punishment?
Well, right away, we see that the Wills Act isn't just strict for the fun of being difficult. Think of it more like a ruthless bouncer at a club aggressively guarding your estate from fraud. Because let's be honest, by the time this document actually goes to work, you, the author, aren't around to verify what you meant or to call out a forged signature. So the law throws up these massive barriers to prevent any manipulation of your final wishes. But the crazy catch here, because these anti-fraud walls are so intensely strict, one tiny honest mistake can literally wipe out an entire lifetime of hard work and completely invalidate your legacy.
Which brings us to Section 2, the ultimate validity checklist, specifically Section 2(1)(a).
Now, this is essentially a pass or fail test. If a document doesn't check these exact 5 boxes, boom, it fails instantly. First up, it has to be in writing. Typed or printed is fine, but no dramatic audio or video confessions. Second, the testator, that's you, must sign at the very end and on every single previous page. Third, you need 2 competent witnesses present together at the same time. And get this, competent just means 14 years or older. So yeah, a literal teenager can legally witness your multi-million rand estate. Fourth, those witnesses only need to sign the last page. And finally, if you're signing with a mark, like a thumbprint, you absolutely must have a Commissioner of Oaths certify.
Let's move on to part 3, amendments and codicils explained.
Because, life happens, and people change their minds. But if you want to alter your will, you're stepping into a whole new minefield of legal tripwires. Let's say you just want to scratch out a name. Under Section 2(1)(b), you can't just cross it out with a pen and call it a day. Nope. To prove no one sneakily messed with your paperwork, you and 2 competent witnesses have to sign in the margin right next to that scribbled deletion. The other option? Codicils. Instead of marking up your original document, you draft a totally separate, clean mini-document. But since it's a separate document, it's treated legally as a brand new will. That means it has to fully comply with all those strict Section 2(1)(a) rules we just covered. I actually love how this works. Think of a codicil like software DLC. Downloadable content, but for your estate plan. It's basically an add-on pack. It says, hey, look at my will from May 2024, but swap out Clause 4. It adds new instructions to your life's legacy without risking the physical integrity of the original file. So your main document stays pristine, clean, and completely free of confusing handwritten scribbles that some lawyer might challenge in court later on. Okay, jumping into Section 4, the court's safety net, found in Section 2(3). This is the rescue provision, or as lawyers call it, the condonation section. Picture this. Someone writes down exactly what they want to happen to their estate, but tragically, they pass away before they can track down that second witness. What happens? Well, the High Court steps in as the ultimate safety net. It actually has overriding discretion to order the master of the High Court to accept a technically defective document as a completely valid will. Sounds pretty great, right? But accessing this net means dragging your grieving family into the High Court. And let me tell you, that is expensive, it is incredibly stressful, and it's famously tough to win. To even trigger that rescue power, you have to pass a super strict 3-part test. Step 1, it has to be a document. Amazingly, case law shows that even an unsent email or a saved Word doc can sometimes count. Step 2, it must have been drafted or executed personally by the deceased.
But step 3, this is where cases are made or broken. The source material highlights this as the absolute gold standard, proving the deceased intended for this specific document to be their final will. If the judge decides it was just a rough draft they were still mulling over, they will absolutely refuse to rescue it. Intention is literally everything here.
Finally, Section 5. Common traps to avoid. Let's troubleshoot some of the most dangerous, real-world misunderstandings out there. First trap, witness disqualification. A lot of folks assume if a beneficiary signs as a witness, the whole will goes up in flames. Actually, scratch that. The document itself is perfectly valid. But, and this is a huge but, the law automatically disqualifies that specific witness from inheriting. So, you didn't invalidate your will, you just accidentally disinherited your most helpful friend. Second trap, thinking the master of the high court can just condone a faulty will. No way. The master legally must reject it initially. Only the high court has the power to save it. And the last trap, signing pages. People think absolutely everyone has to sign every single page. The actual rule? The testator signs every page for sure, but the witnesses technically only need to sign the very last page.
So what does this all mean for us? Well, while the High Court can theoretically save a flawed document, getting those strict rules right the very first time is absolutely the only way to guarantee your legacy is actually protected. You really want to avoid the court system altogether. That's the ultimate goal. So take a look at your own documents, check those signatures, because at the end of the day, you have to ask yourself, are you willing to leave your final wishes to chance? Thanks for hanging out with me for this explainer, and keep learning.